Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a really strange one out of the Cook County Circuit Court in Chicago, Illinois. I will have more for you in just a moment. Lirum Capital Investments and a gentleman by the name of David Rodriguez have sued a prominent law firm in Chicago called Baker and McKenzie. And the gist of the lawsuit, simply put, is that they engaged in professional negligence in how they advised these two individuals during the course of an international transaction. Now, one of the things that sometimes happens with these gigantic mega firms where you have more than 1,000 lawyers in the firm is that you'll have managing partners in different locations. They will be sort of responsible for things that go on in their neck of the woods, so to speak. And then you'll have a general committee that gets together and does things that sort of administer for the entire law firm. And I don't imagine Baker and McKenzie is much different than that, although they do appear to be organized into a number of separate legal ventures. How that will play out in the end is unknown here. At the very least, it focuses the problem here with respect to something called forum non-conveniens. Now, I'm saying conveniens, and that is the Latin term for an inconvenient forum. I'm going to call it FNC simply because that's quicker and we won't waste time with me stumbling over my tongue on convenience. So here we go. Issuing its order, the court cites to a famous work called War and Peace by Tolstoy. And in War and Peace, here is the quote that the judge pulled out. "The strongest of all warriors are these two, time and patience." Well, when a judge starts out an opinion with a quotation, generally speaking, that opinion is going to be epic, and this one certainly tends to fall in that category. So let's look at this. Again, the allegations were for professional negligence. Here's what the court said, sort of giving a general picture of the litigation. The plaintiffs filed a demand that their case be heard by jury. The Baker firm also filed a demand the case be heard by jury. The claims arise out of ownership and operation of the Gremtoyenskaya mine located in the Kemerovo Oblast in the Russian Federation. The court has no view as to the truth of any of these claims or the possible denials or defenses. The claims are that on October 16, 2013, Lirum bought that mine from someplace. Shortly after, Lirum's representative, Igor Rudyk, was detained by Russian authorities and placed in detention. The plaintiffs claim that Rudyk was detained on issues regarding his passport, but this was just a means to extort him. While in detention, Rudyk executed documents which transferred Lirum's interest in the mine to another party. He was held until December 30th, 2013. Plaintiffs claim these events involved misconduct by high local government officials. So, you may be wondering why it is that if this guy transferred the ownership of the mine to somebody else, that Lirum and Rodriguez are not suing him. But for whatever reason, they are not. The court then goes on to talk a little bit about how these allegations relate to Baker and McKenzie. And it says, plaintiffs claim that Baker and McKenzie is an international law firm with its principal place of business in Cook County, Illinois. The plaintiff claims that the business structure appears to be one unified body of thousands of lawyers in dozens of domestic and international offices holding themselves out to the public as Baker and McKenzie. Now, what is the doctrine of forum nonconvenience? The doctrine of forum nonconvenience basically says that when a trial would put witnesses and plaintiffs and defendants, it would make it very difficult for them to try their case, that when that happens, the court can and often does dismiss the action if there is another forum that can undertake the litigation and that will give the parties a fair trial. Although not directly relevant here, the doctrine from Missouri says that the doctrine was developed to prevent a plaintiff from taking advantage of liberal venue statutes to vex, oppress, or harass a defendant by bringing suit in a forum that had no connection to the parties or the cause of action. The doctrine allows and in some circumstances requires the trial court to dismiss a suit if it is filed in a manifestly inconvenient forum. And again, although not directly relevant in this case, in Missouri, the Reederer Court there established 6 factors to be determined, and those 6 factors are the place where the cause of action accrued, the location of witnesses, the residence of the parties, any nexus with the place of suit, the public factor of the convenience to and burden on the court, and the availability to the plaintiff of another court with jurisdiction over the cause of action that affords him a forum for his remedy. Any additional factors to be considered and the weight assigned to each factor are dependent upon the circumstances in each case. A plaintiff's choice of forum is not to be disturbed except for weighty reasons. And although not articulated in the exact same language, that seems exactly to be what the Illinois court is saying here. So, in this situation, we have people who are from London and Spain, that is, Laram and Rodriguez, London and Spain. They are suing this law firm with its offices all around the world, but home-based in Chicago, Now, if this was the other way around, Baker and McKenzie was, for some reason, suing them in Chicago, plaintiffs at that point, Rodriguez and Laram, would have a really good argument for forum nonconvenience because both London and Spain could offer them a potential venue. But instead, what Baker and McKenzie is complaining about is, hey, we got people all over the world, and the people who were involved in this, they're not from around these parts. They're from over there in Russia, and we don't think that trying us here in Chicago is the right thing. So what they've done here is really sort of turn this doctrine, forum nonconvenience, on its ear. In fact, in Missouri, one of the things that Missouri courts frequently say is it cannot be seriously inconvenient for a corporation to defend a lawsuit on its own turf. And you would think that the same would apply to a law firm. Getting into the meat of what they claim, the court tells us this. Plaintiffs claim they discovered a video which shows the governor of Kemerovo Oblast transferring the asset to companies controlled by the Shukin family 2 days before Rudyk supposedly executed the transfer documents. The video shows the governor bragging about the transfer while Rudyk was jailed. Plaintiffs claim the defendants advised them not to use this video as evidence in the arbitrage court proceedings. Therein is the allegation of negligence. They gave advice not to use that video, and by failing to use that video, well, naturally, they lost. In August of 2016, Rodriguez and Baker McKenzie lawyer Roman Butenko met in Moscow at the Baker CIS office. Defendants advised that the shares of the mine had been transferred to a third company, Sereth Holdings Limited, another entity of the Shukin family. The allegation of negligence arises from the failure to use the video. So here is what Baker and McKenzie say about why they should not be tried in their own backyard. Baker filed a motion to dismiss for FNC. They argued that Moscow, Russian Federation, was a more convenient forum for this litigation. They offered in that motion that they would consent to the jurisdiction of the Russian Arbitrage Court in Moscow. The court found that defendant Baker LLP did not meet its burden of showing the factors considered in forum nonconvenience weigh so heavily in favor of the defendant that the plaintiff's right to select a forum should be overturned. In addition, the court found that the defendants did not show the plaintiffs would have reasonable access to a substantially fair hearing and adequate remedy. And of course, that's really sort of at the heart of the American judicial system. If you can't get a fair fact finder and a fair decision, no United States court is going to send you to a court in another jurisdiction. Part of the issue in this particular case is that the court is deciding issues on remand. So initially in 2021, the court determined that Russia was not a proper forum. So Baker appealed that to the Illinois appellate courts, and the Illinois appellate courts said, we don't have enough information. We are remanding it to the circuit court for additional findings. Well, of course, in the interim between the point in time when the original decision was made and the remand, Russia invaded the Ukraine, and travel to and from Russia has been severely limited as a result of that, especially for corporate Americans. The court then goes on to say, on February 24, 2022, during the pendency of the appeal, the Russian Federation invaded Ukraine. Baker sought a stay of the appeal. Baker argues that a court determines at the outset whether an alternative adequate forum exists, an inquiry depending first on whether the parties are amenable to process in the proposed transfer forum. That is not something which a trial court determines at the outset. It then cites a case and says, no, sorry, that's not the way this works, folks. The Illinois Supreme Court directs that courts consider two categories, the private interests of litigants and the interests of the public. As regards the private interests of the parties, the court finds Cook County, Illinois is not a particularly convenient forum for these litigants. No location is convenient. The dispute involves parties and witnesses, some of whom are located outside the U.S. and outside the United Kingdom. In some cases, they are, as best we know, located in the Russian Federation. One party, Baker LLP, the movement, is in Cook County, a few blocks away. All parties appear to be able to conduct litigation and manage the inconveniences. They have already produced affiants and experts from London and the translation of Russian documents. The court does not seek to minimize the inconvenience or expense to the parties, but there is no forum where that would not be a concern. The court has considered the relative ease of access to sources of testimonial evidence, and it found that wasn't necessarily an appropriate consideration. The court then goes on to talk about where Baker McKenzie can be found. And here is what it says. The plaintiffs claim that Baker LLP and other named defendants hold themselves out to the public as providing international litigation services to others. Butenko's letter of engagement from January 20, 2016 lists Baker and McKenzie locations in Almaty, Amsterdam, Antwerp, Bahrain, Baku, Bangkok, Barcelona, Beijing, Berlin, Brasilia, Brisbane, Brussels, Budapest, Buenos Aires, Cairo, Caracas, Casablanca, Dallas, Doha, Dubai, Dusseldorf, Frankfurt, Guadalajara, Geneva, Hanoi, Ho Chi Minh City, Hong Kong, Houston, Istanbul, Jakarta, Jordan, Johannesburg, Juarez, Cairo, Kuala Lumpur, London, Lima, Luxembourg, Madrid, Manila, Melbourne, Mexico City, Miami, Milan, Monterrey, Moscow, Munich, New York, Palo Alto, Paris, Porto Alegre, Prague, Reykjavik, Rio de Janeiro, Rome, San Francisco, Santiago, Sao Paulo, Seoul, Shanghai, Singapore, St. Petersburg, Stockholm, Sydney, Taipei, Tijuana, Tokyo, Toronto, Valencia, Vienna, Warsaw, Washington, D.C., Yangon, Zurich, and Chicago. It then goes on to say this. It would not be unfair to burden the residents of the county with this litigation. One of the defendants in this case is located in this county. It's not the case that because a law firm is nearly everywhere with offices and capacity around the globe that they are ultimately present nowhere. This claim regards the defendant's work as an international law firm, but work which has always been anchored in Chicago for generations. So, what happens? Here's what the court says at the end in deciding this. Illinois lay jurors decide complex matters, including legal malpractice, where the underlying litigation is technical or complex. They do so every day. Baker has not met its burden to show that the factors weigh so strongly in their favor that plaintiffs' right to select the forum should be overturned. Litigation regards parties of different nationalities and different national residencies. It regards events taking place thousands of miles from Chicago and thousands of miles from London. It regards events in Russia, a country that is involved in a foreign war of aggression, which all parties agree is not a proper forum. There is nowhere in the world this litigation can be conducted with easy convenience. It can be tried before a jury in the Circuit Court of Cook County. It is so ordered. So this is a really great opinion. And one of the reasons it's such a great opinion is because it nails down the issues related to forum nonconvenience, and it decides them quite fairly. It basically says, look, you couldn't find a place where this would be convenient. You can't try it in Russia because it's at war in the Ukraine. You can't try it in London because the plaintiffs didn't select that forum. They could have, but they did not select that forum. They want a firm in Chicago sued in Chicago, and that's precisely what's going to happen. A very good determination by this judge, and we will just have to see how this works itself out. So, if you have any questions about this, feel free to leave them in the comments down below. Like, share, subscribe, all the stuff we always ask you to do. And as always, when you have the opportunity today, be kind to somebody. It really will make your day. Have a great day, and we'll talk to you next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.